Good morning, Mr Greenie.
Good morning. Could I begin by reminding everyone that we are broadcasting on YouTube on a delay of 10 minutes, save that those who are present at the venue in Omagh are watching the proceedings with no delay. So on the 23rd of January of this year, the inquiry legal team issued a note on anonymity applications. That note set out a process which invited call participants to file a document listing all anonymity applications which they had in mind seeking, along with a representative selection of applications. The intention behind that process was that the representative applications might be capable of leading to a ruling which determined issues of principle and fact which were common across a cohort of applications, and which might therefore provide guidance for the resolution of most other applications made on behalf of that call participant. In due course, the Police Service of Northern Ireland made applications in respect of 4 retired officers who were referred to in these proceedings as Officers 1, 2, 3 and 5. You heard argument in respect of those applications on the 19th of March. In a ruling dated the 5th of June, which I should say is available on the inquiry's website, so you granted each of those 4 applications. However, in the penultimate paragraph of your ruling, so paragraph 79, you said this, quotes, part of the intention conveyed in the inquiry legal team note on anonymity applications had been that a consideration of representative applications might identify issues of principle and fact which were common across a cohort of applications and thus provide guidance for the resolution of future applications. As matters have turned out, and I intend no criticism in this, so you said, the 4 applications tendered do not really have that effect. 2 relate to former senior special branch officers for whom particular concerns arise, as described in the statement from the head of the intelligence branch. Putting those 2 aside, I'm left with 2 officers who had virtually indistinguishable policing histories and similar exposure to direct terrorist threats. In reality, 1 sample type. The question which arises, and which I do not think has been adequately addressed, is whether any other applicants seeking anonymity would have to demonstrate similar professional histories to this sample type, or be able to vouch similar experiences in relation to threats in order to succeed. It seems to me that this question is best considered in a focused manner at a fresh hearing in light of my ruling in respect of the present applications. Sir, alongside your ruling of the 5th of June, you provided call participants with a note that set out 4 questions that you would welcome assistance in respect of. In response, you received submissions in writing from the Police Service of Northern Ireland, from the call participants represented by PA Duffy & Co, Campbell and Hawley solicitors and Roach McBride solicitors, and from the call participants represented by Fox Law. So today is the fresh hearing to which you made reference in paragraph 79 of your ruling. And we will today invite all the submissions, first of all from Mr Henry, King's Counsel on behalf of the Police Service of Northern Ireland, and then we'll invite submissions from Mr Toll on behalf of the first group of call participants that I mentioned. And so just pausing for one moment, it may be that Mr Toll, King's Counsel, will not need to say anything orally to you today, although he will of course answer any questions that you have. He has been good enough to tell me that discussions have taken place between himself and Mr Henry over the course of the weekend, and that those discussions have led to a large measure of agreement between his position and the position of the Police Service of Northern Ireland. And I'm told that Mr Henry will set out what that agreed position is during the course of his submissions, which may avoid the need, as I've indicated, for Mr Toll to say anything orally today. Once Mr Toll has said anything that he does feel it's necessary to say, sir, we will call upon Mr Southey to make his submissions on behalf of the second group of call participants to which I referred. And finally, Mr Mansfield, King's Counsel, has told me that he may wish to say something brief on behalf of the Rush family. And so having made those very brief introductory remarks, we will call upon Mr. Henry to make his submissions.
Good morning, Mr. Henry.
Good morning, my Lord. May I just check that you can hear me okay, my Lord?
I can, thank you.
So, thank you very much for the opportunity to make these submissions, and we note that the purpose of today's hearing is to try and assist with the provision of further guidance insofar as is possible for the anonymity applications. What I propose to do, my Lord, is to set out in very brief terms a summary of the police position and then go on to discuss some of the issues arising from it, then go on to address your questions, questions 1 to 4 that Mr. Greenie has already referred to, and then finally address the other CP's written submissions. As your Lordship might have anticipated, in terms of my submissions today, they will focus almost exclusively on the Article 2 test, although I will touch briefly on the common law test as well. So in relation to the police position, a useful starting point is just to remind that the Article 2 test is made up of 2 different stages. Stage number 1 is identifying whether or not there is a real and immediate risk to life. Stage number 2, if the answer to the first question is yes, then what is the proportionate measure to put in place to discharge the state authorities' operational duty arising from that real and immediate risk? Now, we say respectfully, my Lord, that on the materials provided in this inquiry, and in particular the JTAC assessment, the Stage 1 test is satisfied, and that's in respect of the real and immediate risk. We say that test is satisfied without reference to the individual circumstances of the retired officers. We also respectfully say that it's at the second stage of the sequential test, so assessing what's the proportionate measure. It's at that stage where an individual's or the individual applicant's personal circumstances are considered. And the most obvious reason why an application might fail on consideration of those personal circumstances is if their anonymity has already been lost. A useful label, we say, which was provided by Mr. Justice Schofield in the Spring Hill decision, was that anonymity was decisively lost, and that's something I'll return to in due course. I just pause for a moment, my Lord, to say that that is not the only potential reason why an application might be refused on individual circumstances. I'm not going to postulate any particular hypothetical scenarios, but we simply don't close the door to there being other exceptional circumstances or circumstances relating to the individual applicant which might lead to an application being refused. So that's a summary, my Lord, of the police position. I'm just going to ask that you turn to paragraph 79 of your ruling, which Mr. Greenie has already referred to this morning, and you'll find that on page 224 of the bundle. And, my Lord, you'll see that taking our lead from the top of the page, about 4 lines down, the sentence begins, "to relate to former special branch officers," and then it goes on to describe the 2 other officers who occupied investigative roles during their police careers. So essentially you have 2 different cohorts. On the one hand, special branch, on the other hand, investigators, and all of whom had experienced issues with their personal security. And the question which you pose 7 lines from the bottom is as follows. The question which arises, and which I do not think has been adequately addressed, is whether any other applicant seeking anonymity would have to demonstrate similar professional histories to this sample type, or be able to vouch similar experiences in relation to threats in order to succeed. So in simple terms, does a future applicant need to have the same kind of or occupy the same kind of role or job within the police, and do they have to have had the same kind of personal security problems that the sample applicants had in order for their request for anonymity to be granted? And we respectfully say the answer to that is no. Insofar as satisfying stage number 1 of the Article 2 test is concerned. Now, my Lord, I'm going to divide, there are really 2 issues in relation to personal circumstances raised in paragraph 79. The role or the job performed by the officer during their time in or service in the police. That could vary from year to year. The police officer, I dare say most police officers will not have occupied the same role throughout their entire police careers. And the second issue is the personal security. Now, I'm going to refer to those collectively, if I may, for the purpose of these submissions, simply as their personal circumstances, and if needs be, draw a dividing line between them in due course. Now, if I might turn to the materials, my Lord, that we say ground the submission that the first stage of the Article 2 test is satisfied on the materials provided. I'm going to start with the JTAC assessment. It begins at page 144 of the bundle. I'm going to ask the inquiry, though, to focus on page 145, please. My Lord, I'm going to make the following observations before reading any portions of the assessment itself, and make the following general observations. And some of this repeats what I said in the earlier hearing. Number 1, the risk, the overarching threat level in Northern Ireland is substantial, which means an attack is likely. The dissident Republicans are assessed as highly likely to view officers and former officers as legitimate targets for any future attack. And the assessment is that giving evidence without anonymity would create a realistic possibility that the threat to those individuals will increase. Now, that assessment is specific to this inquiry and is specific on a sectoral basis to serving and retired officers. And it's on that basis that we respectfully say the first stage of the Article 2 test is satisfied on that assessment alone if it is accepted, and we say that there is no good reason not to accept it. Further observe respectfully, my Lord, that
Is it not a sectoral assessment specific to former officers?
I beg your pardon, if you just bear with me one moment, my Lord. You're quite right, my Lord, the third paragraph of the first page. I beg your pardon, my Lord. So, during the course of the first hearing, I placed some reliance on open source materials and took your Lordship through a chronology of various attacks on serving and a retired police officer, and also other attempts to gain information about those officers. That evidence provides support for the JTAC assessment. But the expert assessment within the JTAC document will be sufficient of itself, we respectfully say. Now, I do emphasise, in case there's any discomfort, with the suggestion that that creates a class-based or category-based automatic grant of anonymity for all former officers within the context of this inquiry. That's not correct, because we do say that the personal circumstances can be taken into account at the second stage. I'll make some further observations, my Lord, about those two categories of material. So that the JTAC assessment, first of all, you will not find within page 144 or 145 any reference to the particular duties of the former officers to whom the assessment relates. Similarly, you will not find any reference within the assessment to their personal security situation experiences. And the significance of that, Lord, is that the assessment which I've outlined, and particularly the last couple of paragraphs of page 145, apply irrespective of whatever duties the former officer performed in service and irrespective of what their personal security experiences were. I move on to the open source materials, my Lord, and I'm not going to go back through those in any particular detail, but just to make a couple of brief observations. You will recall the reference to the murder of Constable Carroll. For your Lordship's note, in the current trial bundle, you'll see information about him on page 121, but I'm not going to ask the court to turn that up just at the moment. You will see that he was a TCG officer and he was responding to a call. The call had been made with the intention that police would respond to it so that whoever responded could be attacked. And on that basis, my Lord, it doesn't appear that an individual officer as such was targeted. It was whoever was going to respond. You will have also heard at the first hearing, my Lord, that that was a constable who was close to retirement at the end of his career. Constable Kerr, you also heard reference to, my Lord. He was tragically killed a short time after Constable Carroll. He is the young constable who was at the very beginning of his career, and the descriptions in the open source materials say that he was a community officer, and he was killed as a result of bomb being placed under his vehicle. So he was specifically targeted. And then your Lordship will also recall, sorry, just before I move on, if you're looking for references in the current materials to Constable Kerr, you'll find them in several places, but at page 119 onwards. Your Lordship will also recall then the wildlife or spy camera that was placed in the hedge of the retired officer. There was a recent conviction in relation to that offending, the offending having taken place in 2016. And so that retired officer was specifically targeted. And the reason I draw those brief examples to your Lordship's attention is that they're, at first blush, certainly doesn't appear to be any particular emphasis placed on the duties that were performed by the officer or their own personal security experiences in relation to the attacks or the efforts made against them. But the more persuasive argument, I respectfully say, is the absence of any such references within the JTAC assessment. My Lord, and I think this might be an observation that the inquiry made within its ruling, but some officers are obviously at higher risk than others. That may be as a result of their of the particular role they played in service. That may be as a result of their personal security experiences. That may be for some other reason. But we do respectfully say that all of the retired officers captured by the JTAC assessment, the baseline, as it were, which is set out within that document, is sufficient to satisfy the first stage of the Article 2 test. Now, my Lord, what I'd like to do next, if I may, is take you to some of the authorities with the intention of trying to persuade the inquiry that the ratio of the decisions to grant anonymity based on, first of all, stage number 1 of the test being satisfied were based on the risk assessments available to the coroners or the judges at that time rather than the personal circumstances. Now, in making that observation, my Lord, I do add one caveat. On some occasions, the rulings are effectively gathered into one. Quite often the common law and the Article 2 decisions are gathered together and follow a recitation of the personal circumstances. But there are instances, I respectfully say, where it's quite clear that the judge or the court was making the decision based in relation to stage 1 on the risk assessment that was available at that time. So if I could ask the court to start with the decision of then Mrs. Justice Keegan in the Ballymurphy inquest. And that decision starts at page 1120 in the bundle. I'm going to ask that the court turn up paragraph 21 on page 1132. If your Lordship has paragraph 21 in front of you, you'll see within it, then Mrs. Justice Keegan identifies the test from the C's application case or Officer C case decided by the Court of Appeal in 2012. She states, having regard to the observations of the Northern Ireland Court of Appeal on the engagement of Article 2 in the matter of an application by officers C, D, H and R, and then gives a citation. The question arises as to whether the evidence before the coroner establishes a real risk to life that is neither fanciful nor trivial, and that is present or will be present if a particular course of action is or is not taken. And just pausing there, that's very clearly a reference to Lord Justice Girvan's decision, in particular paragraph 43 of that decision. She goes on to observe at the end of paragraph 21, in that case, so C's application, the decision was directed at police officers serving in Northern Ireland, and whilst that may comprise a particular category, the risk remains for military personnel who served in Northern Ireland who may be asked to come to Northern Ireland and or retired police officers. So moving down to the next page, my Lord, paragraph number 23. The decision reads, of course, the present evidence relates to an ongoing dissident threat that has been evidenced by a number of incidents in Northern Ireland, and I was provided with press briefings in which that threat was very definitely described as real, continuing and present. So it is clear that Article 2 is engaged in these cases. Just pausing for a moment, Lord, there isn't any reference to what I'm referring to as personal circumstances within the ratio of that decision. I'm going to take you back a few paragraphs in the decision to where there is a reference to personal circumstances, but it clearly doesn't feature within the determination that stage 1 of the test is satisfied. I'm also going to take you, my Lord, to this is the, if you like, the global decision. There's an annex to it in which a number of individual anonymity decisions are taken where they, I'll take you to an example of one of those as well. So if I may ask your Lordship to go back to paragraph number 17. So this is on page 1129. And if your Lordship has that available, I'm going to start halfway down through the paragraph at the end of the page. The sentence begins, hence, comma, I tried to streamline. Prior to that, she's talking about the procedure. So it says, hence, I tried to streamline applications in this inquest for the benefit of future inquests as follows. The procedure is that there is an initial submission of an application which must be in writing. It is important that there is a separate application for each applicant because, along with the objective evidence of risk for an applicant coming to give evidence in an inquest in Northern Ireland, consideration must be given to the subjective fears which an applicant may have. I'm going to respectfully invite the tribunal, or the inquiry rather, to consider that in the following way. She is referring to the objective evidence, so the threat assessment and open evidence in relation to the objective threat, stage 1 of the Article 2 test. And I respectfully say, is clearly referring to the personal circumstances and the subjective fears in relation to the common law test. So, my Lord, I said I would take the court to, or the inquiry to, one of the individual decisions annexed to the Ballymurphy findings.
Just before we do that, Mr. Henry, could we look again at paragraph 23?
Certainly, my Lord.
Here the Lady Chief Justice explains that the evidence related to an ongoing dissident threat was evidenced by press briefings.
Rather than the assessment.
Yes, and she says that those press briefings demonstrated the threat was very definitely real, continuing and present. So it's clear that Article 2 is engaged in these cases. So does that mean that one could determine that Article 2 was engaged on the basis of these open source material alone without taking account of the threat assessment?
I think so, my lord. You're not left in that position where that is all you have. And you'll see by reference to the individual decisions in the annex, annex number 2, that equally that was not the position that Mrs. Justice Keegan was left in. No. But arguably, one could draw that from paragraph 23. I'm not going as far as that because we don't have to. You are in a similar position to the coroner in that case, where you have both sets of materials. And it may be that if you have an expert assessment of risk, that perhaps is the better starting point, and then that is fortified by the open source materials. But one could arguably say on the open source materials and a common sense approach to the chronology of attacks that they set out, that is enough for stage 1 of itself.
And if one was doing that, then that would point away from the need for individualised threat assessments.
At stage 1, yes, my lord.
Thank you. So you were going to ask me to look at the addendum section, I think.
Yes, my lord. It's quite a bit further down than page number 1171. And I should say, my lord, there are more than one individual decision. So this is. I'm just choosing a sample. I don't wish the court to think that this is the entirety of these anonymity decisions. And so that once your lordship reaches page 1171 at the top, you'll see the individuals' former soldiers by their ciphers, each beginning with M. You'll see the date of the decision, and it's paragraph 3 that I would like the inquiry to focus on, please.
Yes.
If your lordship has 3 in front of you, then it reads, in reaching my conclusion, which was a positive one, I have reflected on the argument that the threat level is described as low. However, in my view, it is sufficient that this could potentially rise. That is clearly in reference to stage 1 of the Article 2 test. She comes back to the Article 2 test in just a moment. She also says, also the fact that nothing has happened to military personnel in the past does not mean that something could not happen in the future. In this regard, I bear in mind the recent events in Northern Ireland and the nature and profile of this inquest. Having consideration to all of the above, I am satisfied that Article 2 is engaged in each of these cases. And then she goes on to describe a positive decision and that anonymity is the bare minimum. Now, I appreciate that by the time she reaches the grant of anonymity, she has come to the conclusion of stage 2. I'm only focusing on stage 1 at the moment. But it is, in my respectful submission, relatively clear that the ratio of the decision there is reached on the basis of the threat assessment on stage 1. Lord, I'm taking the judgments in the order that they appear in the bundle, so we're going to head a little bit back in time next, unless your lordship has any queries about the Ballymurphy decision. I'm going to ask you to turn up C's application. So this is the Court of Appeal's decision, and specifically Lord Justice Girvan's judgment within it. And that is page 1225 and 1226.
What were the page numbers again? Sorry, Mr.
At the bottom of page 1225, and it's the paragraph 43, which has received a lot of attention already. You'll forgive me, my lord, for going back to this, but I'll not labour it. So at the beginning of 43, Lord Justice Girvan states, those authorities which he's reviewed above, albeit in a different context, together with Lord Dyson's contrast between fanciful risk and a significant risk, lend support to the view that a real and immediate risk points to a risk which is neither fanciful nor trivial and which is present, open brackets, or in a case such as the present, will be present if a particular course of action is or is not taken, close brackets, pausing there. So that is the test, as it were, which is repeated in a number of different Northern Ireland decisions following this judgment. Lord Justice Girvan goes on to say then, in a stable and law-abiding society, the risk of homicidal attacks on an individual is fortunately rare, and statistically will be a very uncommon occurrence. Before the state can be fairly criticised for failing to prevent a homicidal attack, it is right that the circumstances must bring home to the state authorities that a person is under a threat of substance. And over the course of the next couple of lines, Lord Justice Girvan refers to the French text of the Osmond decision, which sets out the basis for the operational duty. And after that, he says, in the context of Northern Ireland, which has been subjected to decades of homicidal attacks on individuals by organised terrorists, the threat to life has been real, though for the bulk of the population, it is not a threat directed at them individually, so that for most, the risk is not present and continuing in the sense of immediate to them. And here we get into the important territory for the purposes of the present application. He continues, for some, such as members of the police force, the level of threat has been and continues to be at a much higher level, and it is much more immediate. It cannot be considered as anything close to fanciful, and it is significant. The requirement to give evidence imposed on officers involved in this inquest will according to the evidence, increase a present threat, possibly significantly depending on the nature of the evidence and on other unknown contingencies arising out of the inquest. The risk accordingly must qualify as real, continuous, and present. I go to respectfully suggest, my lord, that the reference to the present threat, which is being described there, is not informed by the individual circumstances of the officers in that case. And what Lord Justice Girvan is saying there is that that of itself is sufficient, and that line or that approach has been adopted by the coroners and judges in the decisions which have followed, and without challenge. Right.
When it talks about the requirement to giving evidence increasing a present threat, you say that that's the thrust of the decision there. And the fact that that threat might increase significantly for some is neither here nor there.
Correct, my lord. And I'm not sure whether it's within the C decision itself. I'm quite sure it is, in fact, within Lord Justice Girvan's discussion, that the amount that the threat might increase, so whether it's significant, the increase is significant or not, is incalculable. So it's impossible for an accurate assessment for that to be undertaken. And for quite understandable reasons, the difficulties in making those kind of prospective, predictive decisions.
So, for example, you might have what I think you've touched on in your own submissions as something you might think of as a so-called high-risk target. And accordingly, for someone like that, the threat would be increased significantly if they gave evidence. But for another officer who didn't warrant that categorisation, the threat would increase, and that would be sufficient.
That's correct. It wouldn't increase to the same magnitude necessarily. So take a hypothetical example. The head of special branch or the head of a regional special branch office might face a greater level of risk than a constable who was performing routine day-to-day duties, which he is required or she is required to speak to during the course of this inquiry. The level of risk might be different. The magnitude of the increase, rather, in risk might be different between the two of them, but for either, it's sufficient. It's the that basic point of some officers face higher risk than others, but the baseline is sufficient to satisfy stage 1. If you just bear with me one moment, please, my lord. Yes, the incalculable extent of the risk is referenced within, I'll not read it out for your lordship, but it's referenced within paragraph 46 of Lord Justice Girvan's judgment, and then also repeated by Mrs. Justice Keegan, as she was then Mr. Justice Huddleston and Mr. Justice Schofield subsequently. The C's application judgment. I'm going to move on next to the Spring Hill inquest judgment, and I'm going to ask that your lordship go to page 1798 and starting briefly at paragraph 29. So that's 1798, paragraph 29. I simply take you to paragraph 29, my lord, so you can examine the subtitle above it, because it's to place into context that this judgment is dealing with a number of different issues, one of which is anonymity. So the discussion about anonymity begins at paragraph 29. You'll see reference within it to the Article 2 test, C's application. At paragraph 30, you'll see a discussion about, in general terms, about the common law test. And then at paragraph 31, you'll see reference to the threat assessments provided in relation to those the applications in the Spring Hill inquest. There's quite a detailed discussion about the contents of those risk assessments and the low risk assessment, which was uniform across all of the applicants, but some differences about how they would work out, depending on whether the individual gave evidence within Northern Ireland or within Great Britain.
If we pause at paragraph 31, we can see that Mr. Justice Schofield explains that he has been provided with a number of threat assessments. And he says they are now in a standard form.
Yes, ma'am.
And he explains that the point's been made to him that there is not a threat assessment for each witness. Now, when you presented your principal submissions to me, if I remember correctly, I think I touched on this in the ruling, you explained that there was a process agreed which resulted in JTAC taking responsibility for providing threat assessments, and that the timing of that was
2024.
2024, yes. So is that what Mr Justice Schofield is describing as well?
I can't speak definitively, my lord, to which side of the threshold that falls on, whether it's pre or post JTAC taking over responsibility. But what one might reasonably infer is that, and you will have seen this in a number of the legacy inquest anonymity decisions, that whilst individual assessments were being provided for each applicant, the contents were the same, and one can make a reasonable inference as to how we arrive at a situation where JTAC now do sectoral assessments for individuals falling within the same category, rather than, say, supply 5 or 10 individual assessments which all say the same thing but have an individual officer's cipher at the top.
Even before that, if we think back to what Lady Justice Keegan said in the Ballymurphy inquiry, risk assessments appeared to have been of a generic nature.
That's correct, Lord.
So, what did you want me to look at in
it was paragraph, so bearing in mind we have this fairly detailed discussion moving on from paragraph 31 and 2 about the nature of the and content of the threat assessments. If I could respectfully draw your attention down to paragraph 38, please. Now, this immediately follows that detailed discussion about those threat assessments. Mr. Justice Schofield says, notwithstanding this, he's referring to the low assessments and so forth, I still consider it reasonable and proportionate to grant anonymity in these cases. The grant of anonymity would plainly be appropriate in my view if the witnesses were required to come to Northern Ireland. The question is whether they should be deprived of that protection merely because for now they are not required to do so. The context of that, my lord, was that the former soldiers were being granted live link applications to give evidence from elsewhere in the UK. He then goes on to say, in the Doherty and Fleming inquest, Huddleston J indicated expressly that he was going to adopt a precautionary approach, and he was urged to do the same with reference to Jordan. And then below that, in a variety of recent legacy inquests, former military witnesses have been granted anonymity, even though they have not been permitted. They have also been permitted to provide evidence remotely. Paragraph 39, my lord, bearing these matters in mind, I consider it appropriate to grant anonymity, even though the witnesses will not, brackets, presently, close brackets, be required to attend court in Northern Ireland for the purpose of this inquest. I have concluded this to be the case on the basis of both Article 2 and common law. Now, I appreciate, Lord, I mentioned earlier, sometimes it's difficult to disentangle the ratio between the Article 2 decisions and the common law decisions. I do respectfully suggest that in relation to the first stage of the Article 2 test, it appears fairly obvious that Mr. Justice Schofield is relying exclusively on the threat assessments. My Lord, I have one further example, which is Doherty and Fleming. Now, I'm quite happy to take the inquiry through it, or if you would prefer me to simply provide you with the page and paragraph numbers, I'm equally happy to provide those and move on to my next point, whatever the inquiry's preference would be.
Well, we have 3 Doherty and Fleming decisions. I'm familiar with each of them. So if you want to just direct me to the passage that you're interested in, that would be fine.
Yes. So it is the 2023 Northern Ireland Coroner 17 decision. The particular paragraphs that I rely on are paragraph 10 on page 1831. And also in the addendum to that judgment, my Lord, paragraphs 8 and 10, so they deal with two different former police officers. So paragraphs 5 and 10, and they are both found on page 1833. I beg your pardon, 1833 and 1834. The submission is exactly the same, my Lord. One can reasonably deduce from those paragraphs that the Stage 1, Article 2 decision was made on the basis of the assessments. With your Lordship's permission, what I would intend to do next is turn to the second stage of the Article 2 test. As you've heard already, the PSNI accepts that personal circumstances are relevant to that. It's fairly obvious, my Lord, from the wealth of legacy inquest decisions that we have and decisions in other outside of the legacy inquest forum, but still within Northern Ireland, that frequently these kinds of applications are granted for former police officers. Although I appear only for the police, they are frequently granted for military witnesses as well, or former military witnesses, but not always. One of the examples as to when such an application was refused was in one of the Doherty and Fleming decisions. So it is the 2024 decision. It related to the former officer by the name of the cipher rather, PW9. For your note, my Lord, that decision starts in the bundle at page 1786. The key paragraph for the present purposes is paragraph number 6 on page 1787. And if your Lordship would just bear with me one moment till I turn that up. So by this, sorry, my Lord.
Yes.
By this stage, we've already had at least, well, there are two Doherty and Fleming decisions prior to this within the bundle, both relating to 2023. Mr. Justice Huddleston has already gone through the law in those. He goes on then in relation to PW9 in paragraph 6 to say the following. The present application was made late in the day insofar as information in relation to PW9, principally his name, was already known, and he says see above. That being the case, I see no strength whatsoever in his claim for anonymity. His application is based primarily on the grounds that he remains concerned for his own safety and that of his family. Even though PW9 has expressed concerns, and I accept that he may have a genuine basis for doing so, the question for me is what is appropriate in the present scenario. Firstly, as I've said, his application was made late in the day. Secondly, it was made at a point in time when his name had already been known in connection with these proceedings for a significant period of time. Finally, his name has already been repeated, according to the next of kin, in excess of 40 times in public in connection with these proceedings. and the public reference is not unimportant, my Lord. In those circumstances, I, in concluding the balancing test, have concluded that he is not entitled to anonymity. That is what distinguishes his case from my earlier rulings on the question of anonymity, which had been largely successful for the former security forces applicants. So there we have a clear example of a member of the judiciary deciding that it wasn't appropriate to grant anonymity on the basis that anonymity had already been lost. That was self-evidently on both the Article 2 test and the common law test. But in those circumstances, my Lord, the former officer, PW9, was, in so far as the first stage of the Article 2 test was concerned, was in exactly the same position as the other former officers who were all successful. I'm going to, unless your Lordship has any queries about paragraph 6 or that decision in general, I'm going to move from Doherty and Fleming back to the Spring Hill judgment from Mr. Justice Schofield, where he touches upon this issue of loss of anonymity. And in particular, I'm going to ask the inquiry go back to page 1802. So that's 1802 and paragraph 42.
Can I just check before we do this, Mr. Henry, just how we stand in relation to the stenography? Do we need a break?
Thank you, my Lord. Now, where I'm asking the inquiry to pick up here is paragraph 42. Now, by this stage in the judgment, we know that the other applications for anonymity have already been granted, but he's carving out two applications in particular for separate consideration. Both of the applicants were former Royal Military Police investigators. And you'll see within paragraph 2, he states that it was brought to his attention by the next of kin that those two individuals had already given evidence under their own name in the original inquest proceedings in 1973. And so quite understandably, the next of kin submission in the subsequent inquest before Mr. Justice Schofield was, well, we already know their names, they've already been disclosed in these proceedings, therefore their applications for anonymity should be refused. Ultimately, that submission was unsuccessful because ultimately Mr. Justice Schofield granted their applications for anonymity. With paragraph 43, he refers to PW9, the decision that I've just taken you to. There appears to have been another refusal as well, PW35, by Mr. Justice Huddleston, also referred to in paragraph 43 of Spring Hill, albeit we don't have that, at least I don't think we have that decision for you in the bundle. But it's paragraph 44 that I'm going to take you to next, my Lord. Mr. Justice Schofield says, I have considered the rulings in those cases, so PW9 and PW35. To my mind, Mr. Justice Huddleston was making the common sense point that if anonymity has been lost to such a degree that the application is plainly pointless and granting it would therefore bring the procedure into disrepute, the application should be refused. This will be appropriate, for instance, where, as there appears to have been in those cases, there has been recent and widespread publication of a witness's name in connection with the very proceedings in respect of which anonymity is sought. I have referred to this at paragraph 38 above, in the shorthand phrase of anonymity having been decisively lost. Just pausing there, my Lord, but the inquiry will take its own course, but the PS and I would respectfully promote that as being quite a useful label to attach to this area. Continuing with the judgment then, Mr. Justice Schofield says, obviously each case will turn on its own facts and will be context specific. However, in the case of SM 344 and SM 346, I do not consider them to fall into the category where the absence of anonymity in 1972 and 1973 means that there is no purpose to be served by it being granted now. It is unclear whether there was any reporting of either witnesses' names some 50 years ago. There is limited, if any, evidence of their names being disclosed publicly, albeit they may have been available to someone who had access to the original inquest papers. There is no evidence of their names having become known in a widespread way recently or otherwise in connection with the present proceedings. So that's how he arrived at his decision in respect of those two individuals. Now, we respectfully observe, my Lord, that in order to arrive at a decision on whether anonymity has been lost, that necessarily requires consideration of the personal circumstances of the individual. That could fall under a number of different subheadings, and I wouldn't wish to be prescriptive in relation to that, but their previous role and or their previous personal security experiences may be relevant to that, but the focus will be on the issue of whether anonymity has been lost, or as Mr. Justice Schofield says, decisively lost. He uses the language of widespread and recent publication or publicity in relation to their names. Now in our written submissions, we used an example at the extreme to demonstrate how that might pan out within the context of this inquiry. We chose the former Chief Constable from 1998, and if he made an application for anonymity in connection with these proceedings within this inquiry, although he would still satisfy the stage 1 test, consideration of his personal circumstances would mean that a grant of anonymity would be, using Mr. Justice Schofield and Huddleston's language, pointless, and perhaps bring the process into disrepute because his anonymity will have already been lost, and obviously so. Just one final observation to make in relation to this area, my Lord, and I think I touched on this in the opening. There may be other unforeseen reasons towards the extreme, aside from anonymity, or a loss of anonymity as to why an application could be refused at the second stage. We're not suggesting the inquiry should close the door to that. We've difficulty foreseeing hypothetically what that may be, but we did acknowledge it in our written submissions at paragraph 63, the penultimate paragraph of our conclusion section, and said that there may be other circumstances which warrant refusal, and so respectfully we don't suggest closing the door on that. So, my Lord, if I might then turn to your 4 questions, please. They appear in the bundle on pages 225 and 226.
So say that she could go for an hour and a half. But bearing in mind where we're this will be the time.
Would that be convenient, Mr. Henry?
Certainly, my Lord.
I wonder if we could break so until, should we say, half.
Yes, Mr Henry.
Thank you, my Lord. Where we left off before the break was at the point when I was beginning to attempt to answer the questions you posed, and the questions begin on page 225. And the first question refers to the 2024 decision of Mr Justice Huddleston in Doherty and Fleming. And you ask about two aspects of paragraph 3, and they are as follows. Firstly, the risk to former members of the security forces, including former police officers, remains both subjectively and objectively something that is real and not fanciful. And then the second component of paragraph 3 states, even taking into account the threat assessment now provided, one could not discount the possibility that giving evidence without the benefit of special measures could increase the security risk to those who attend and give evidence. Just pausing for a moment and dealing with the first of those two components. In our written submissions, perhaps in a more laboured way than we ought to have done, we just drew attention to the distinction between the objective and the subjective components of the risk, and that insofar as Article 2 is concerned, and in particular Stage 1 of the Article 2 test, we're only concerned, we're principally concerned with the objective test. And the question that you have posed after those two components...
Mr Henry, could I ask you just to pause for a moment?
Certainly, my Lord.
Something seems to have happened to my transcript. Oh, it's back again. Thank you.
So, my Lord, the question that you posed at the end of, or after those two components, was this: do these two factors describe the circumstances in which Article 2 is likely to be engaged in respect of a former police officer witness? And rightly or wrongly, my Lord, I have understood the word engaged to be a reference to the Stage 1 of the Article 2 test. And that being the case, we say firmly that the answer is yes. Consequence of that is that you then move on to the second stage of the test. So, unless your Lordship has any queries in relation to that, I'm going to move on to question number 2. And it asks as follows: proceeding on the basis that it is correct to assume a general or background level of risk to former police officers which is objectively real and not fanciful, what is the consequence of giving effect to the following two components of the JTAC threat assessment dated the 22nd of July 2025? And those two components are: 1, dissident Republicans highly likely view former RUC and PSNI witnesses at the inquiry as legitimate targets for attack. And 2, should any former RUC or police witness give evidence without anonymity, there is a realistic possibility that the Northern Ireland related terrorism threat to those individuals will increase. And we say simply, my Lord, that consequence of giving effect to those two components is that the Article 2 test is met. I should say Stage 1 before one moves to Stage 2. Question number 3 then. In the second mentioned component of the JTAC assessment, is the second mentioned component of the JTAC assessment to be read and applied literally? So that's the reference to the realistic possibility of increase in risk. And we say the answer to that is yes, it should be applied literally. In our written submissions, we expand on that a little bit more and describe it being the expert assessment as reliable as the inquiry is going to obtain. And
I wonder if I've maybe been a little less clear than I could have been in relation to this question. What I really had in mind was the import of the word any. And I think I would now understand your answer to that would be that that brings into play the concept of decisive loss of anonymity.
Assessment, Lord, I wouldn't disagree with that. So, my Lord, question number 4 deals with the precautionary approach. And your query in very simple terms was, does it apply to stage 1, or does it apply to stage 2, or does it apply to both? And within the parameters of the question, you've referenced the Doherty and Fleming decision, in which it appears to refer to the stage 1, and some other decisions where it appears to have been applied at stage 2. Not in advance of drafting our written submissions, but in preparation for today, my Lord, I noticed that Mr. Justice Schofield appeared to have endorsed what Mr. Justice Huddleston said in Doherty and Fleming when he was drafting the Spring Hill decision. So there might be further support for it applying to stage 1 beyond Mr. Justice Huddleston's approach, but that's something the inquiry can consider in due course. So we reflected on this general question carefully, stage 1, stage 2, or both. And our respectful submission is that it can apply to both as a valid consideration. And in order to arrive at that position, we went back to the reasons for the precautionary approach articulated by Mr. Justice Stevens, as he was then in the Jordan decision. And in paragraph 118, which I won't take the inquiry to just at the moment, in very simple terms, he referred to not acting, the precautionary approach was not acting without good reason or evidence, but 1, the consequence was serious, namely death, and number 2, there is an inherent difficulty in making a predictive decision. One doesn't know what future events are going to unfold. One doesn't know what is going to happen during the course of the inquiry with the requisite degree of certainty. One doesn't know what a witness is going to say. One doesn't know what publicity will be attracted. One doesn't know how a dissident Republican or a group of dissident Republicans are going to react, or what attention they're going to be paying, and so forth. All of those uncertainties make the predictive decision-making process very difficult. And bearing in mind the underlying reasons for the precautionary approach, it's difficult to think of a good reason why it shouldn't apply at the first stage as well as the second stage. The court or an inquiry might feel that there's no need to rely on it at the first stage, because if one applies or accepts the assessment within the JTAC assessment or whatever threat assessment is provided in another case, if that's sufficient and one is suitably satisfied by the assessment that's set out within that document, there isn't a need for a cautious approach or a precautionary approach in those circumstances. But in principle, my Lord, I see no reason why it couldn't apply at the first stage. And in relation to the second stage, what measure should be employed in relation to or by the state authority to discharge its operational duty obligation? It does fit naturally there that a precautionary approach would be applied because of those two underlying reasons, the seriousness of the consequence and the difficulty in predicting what's going to happen. So those are my respectful observations in relation to question 4, my Lord. If there are no further queries about that, I would move on to the final and brief observations that I would make in relation to the other court participants' submissions. So before I make these observations, my Lord, I just say one thing, and this is just as a consequence of timetabling, it's not intended to be critical in any shape or form. When each of the CPs who were responding in writing for the purposes of this hearing were drafting their submissions, we hadn't seen one another's written submissions. And so that's why we had the constructive dialogue between Council over the course of the weekend to see whether there was any measure of agreement or a lesser measure of disagreement between us. And I know that with everyone having reflected on what the others have said, I know that Mr. Toll, for example, isn't advancing the category submission, which is contained in the written document provided in advance.
Do the individual submissions prepared by court participants not get circulated to the others?
We all saw one another's, but not. So it's if you like, it's the police application, but Mr. Southey and Mr. Toll wouldn't have had the benefit, I don't think, of seeing my submission before they drafted their own. And that was simply a matter of the condensed timetable. It wasn't. Normally they are sequential. So normally, in most instances, ours will go first and the non-state CPs will reply to those. But I just think in this situation, because of the short time frame within which those submissions were required, everyone was given, subject to correction, but I think everyone was given the same deadline. And I know it's different in other jurisdictions, but that was in the run-up to a very busy end of term period in Northern Ireland as well.
I just seem to remember myself receiving all of them quite some time ago.
That's right, my Lord, but they were drafted without sight of one another's, and that's the observation I'm making. So
I can confirm that as the position. There was a single date for the receipt of all submissions.
And that date was given, my Lord, when this was an earlier hearing date, and that date was fixed to give everyone a fair opportunity to read those written submissions prior to that hearing date. So that's why we readily understood that there was the same date for everyone. So with that in mind, my Lord, I make two final observations. Number one, the key concern that I drew out of both CP's written submissions was their concern about individual consideration of applications. And insofar as I'm talking about stage 2 of the process, of the Article 2 test requiring individual consideration, then I don't think there's a difference between us. And insofar as there is any requirement, if the Article 2 test is not satisfied, to turn to the common law test, then it's obvious to all involved, I think, at that stage, that personal circumstances are a significant consideration in the common law test process. The final then observation, it relates to what I would call the accountability or public interest point that is raised in both sets of non-state CP submissions. And in very simple terms, my Lord, the point that has been made is if a witness is particularly important, then there should be a greater reticence about granting anonymity. And our answer to that in relation to Article 2 is that it has no place, it has no valid place for consideration. So if we break that down, Lord, stage number 1, is there a real and immediate risk? That query is answered obviously without reference to the importance or absence or lesser importance of an individual witness's evidence. That's the easier consideration. Stage number 2, then, what is the proportionate measure to employ in response to a real and immediate risk? Well, it's important when considering that, my Lord, to think about what the inquiry, or in a different context in court, is being asked to do. It's been asked to judge what is a proportionate measure to employ to protect life, and it would not be an acceptable position for any inquiry or court, we say, to reach a conclusion where it said, well, there is a risk to this witness's life, but that is tolerable because their evidence is particularly important for the purposes of those proceedings. That would be completely out with the spirit of the Convention, which gives rise to Article 2. My Lord, I'm very grateful for your patience with me this morning. Those are my respectful submissions. If you have any additional queries, I'd be happy to try my best to address them. But otherwise, that's all I have to say this morning.
Thank you very much, Mr. Henry.
Thank you.
So Mr. Toll has confirmed separately to me that on reflection and following his discussions with Mr. Henry, he is not persisting in the submission which is based upon the categorisation of witnesses that is set out in paragraph 37 of his written submissions. Moreover, the anxiety that those he represents have had that you might be encouraged to determine applications on a class basis has been dispelled by the submissions of Mr. Henry this morning, that they make no such submissions. And in those circumstances, it may be that Mr. Toll does not feel that there's anything he wishes to say orally, but I will check that with him. But that is the position.
Well, I think I need to know just a little about what to make of the other paragraphs in Mr. Toll's submissions as well.
So Mr. Toll has been very clear with me that if there are questions that you have for him, he will of course answer them.
Yes. So Mr. Toll, can I just be clear then, in paragraph 37, where you suggest an approach of identifying different categories, we can put that to one side?
Yes.
What about paragraph 18, where you say that before anonymity is granted, a variety of different issues should be considered?
Just give me one moment, please. Page is that on the bundle? 244. Yes, that is aligned with the earlier submission, Chair. So that is not necessary in the circumstances.
So I can put that aside as well?
Yes, please.
And what about those paragraphs from, say, 28 to 33? There was an issue of accountability brought into play, and an approach you suggest should be taken according to things such as whether or not the witness is central to the narrative of preventability, intelligence handling, threat assessment, etc.
No, insofar as Article 2 is concerned, they are not relevant, but obviously the common law test will require all available factors to be considered, Chair.
what about this suggestion, which is very similar to what was advanced in the initial hearing, that there should be a sort of dissection of anonymity, and distinguish between disclosure to various individuals and other factors of that sort?
No, you have already ruled upon that, and we accept that ruling, sir.
Okay. All right, thank you then, Mr. Toll.
Thank you.
Thank you, Mr. Toll. And so, as I indicated at the outset of the hearing, we will now invite Mr. Southey to make submissions on behalf of those that he represents.
Can I start by making clear a couple of things, which hopefully should be clear from our written submissions. Firstly, we're not seeking to re-argue or repeat submissions that we made during the last hearing in relation to anonymity. That's to some extent why we've focused on questions, and in oral submissions today I'm going to focus on your questions. I should add to that that, as my own friend Mr. Henry indicated, there were helpful exchanges over the weekend between all counsel, and I agree with him that there may not be a huge difference between him and I in relation to what we're seeking. Linked to that, I should make it clear before I go into the detail of the case law that we accept that in principle it would be open to the inquiry to reach what might be described as generic findings that that are a starting point essentially when assessing individual cases, but there still needs to be individual consideration. The most obvious reason why there needs to be individual consideration is because in practice anonymity would make no difference. The most obvious example of that, we agree with Mr. Henry, is where anonymity has effectively been lost. But there can be other cases. So an example which may or may not arise on the facts of, for example, someone who's a resident in Australia at an address totally unknown to people, for example, where he would be or she would be unlikely to be located. Picking up from that, on a theme, on a submission that Mr. Henry ended with, we would also argue that importance of the naming of the individual could, at least in principle, potentially justify naming them, even if there is a real and immediate risk resulting from them giving evidence. So you will remember, I'm sure, what is said in Osman. It's at page 609 of the bundle, the relevant passage, para 116. But that makes it clear that the requirement effectively, and I'm paraphrasing, but hopefully not inappropriately, that makes it clear that the obligation on the authorities are to act where there is a real and immediate risk, but they're not required to take disproportionate steps. And in our submission, at least conceptually, it could be the case that the importance of a name is such in the particular circumstances of the case that it becomes disproportionate to make an anonymity order as opposed to providing some other form of protection. And to give, in one sense, an example of that, and I should make it clear on the material we've seen so far, I'm not suggesting actually necessarily this arises in the circumstances of this case, but if you think about policing in Northern Ireland, it would plainly be unacceptable for the senior leadership of the police to be unknown. Chief Constable, his deputies are known.
That's. I'm so sorry to interrupt. I've had a message that those on the link particularly difficult to hear. I think it may, I'm not saying he shouldn't sit down, but perhaps there could be a slight adjustment.
Yeah, I think
I'm so sorry.
No, that's helpful. Sorry, it may be that. Can I just move the microphone forward? Sorry, I've got problems with table space, if I can put it that way. But hopefully, I don't know if those messaging Mr. Mansfield can confirm whether or not that's better. I suspect it may be.
I think so already. Yes, thank you.
Thank you. Thank you. I won't repeat myself, but the point I was making was about importance. For accountability reasons, it's obvious that the Chief Constable has to be a public figure. The Chief Constable gets provided with protection, and that's something that is a proportionate response. All I'm saying is that one shouldn't rule out the possibility of importance being a factor. Particularly in one sense, it's a factor that may need to be kept under review. If, for example, there was something very serious that was said about a particular officer, it shouldn't be ruled out the fact that importance might, in those circumstances, justify naming the individual. But I would emphasise, I've seen nothing. I'm not making that point about a particular application or a particular officer at this stage.
I think this is a point you touched on at the previous hearing, Mr. Sully, and if I remember correctly, what I tried to acknowledge in the ruling was that, whilst that might well be right, there wasn't an example of it.
No.
And so you're holding on to the principle, and I don't really have any difficulty with that.
I was only really holding on to it because it had been expressly raised in Mr. Henry's oral submissions, and that's why I was responding to it, because in one sense what I'm trying to do is identify in one sense where the differences are between us.
Yeah. So the door is open to other considerations, as Mr. Henry recognised, and they would just be dealt with on an individual basis.
Absolutely, and I recognise that. It was just the particular submission I thought I should put a marker down that we don't accept. Turning then in one sense to perhaps more substantial issues, clearly there doesn't appear to be any dispute. The ruling makes it clear that there are two stages to the Article 2 obligation. One is the assessment of whether or not there's a real and immediate risk. The test that applies in relation to that is clear. And secondly, what is a reasonable step? Now, as I read your previous ruling, you, sir, appear to accept, and I reference particularly para 17, 61 and 64, that at some stage, and this may be an area where there's dispute between myself and Mr. Henry, albeit it may not matter in practical terms as well, you appear to accept, we submit correctly, that what one needs to, at some stage at least, consider is whether the action of giving evidence will result in a material increase in risk. And that's clearly why both parties, not both parties, but why there's been a focus on the submissions on the issue of whether or not anonymity effectively has been lost. Because obviously, if anonymity has been lost, it's difficult to see how there will be an increase in risk. Mr. Henry says that only comes into play at the second stage when looking at whether or not there's steps are reasonable. We submit it comes into play at the first stage, and we submit it comes into play at the first stage because ultimately the question is the state effectively interfering with the rights of an individual by putting them at risk? And if the actions of the state, which in this case would be the failure to grant anonymity, are not putting the person at risk, we say Article 2 isn't in play. Having said that, I'm not sure in one sense it makes a huge amount of difference, because both parties agree it has to be considered. And if ultimately the question is there a material increase in risk, that's a factual question that both parties agree needs to be considered in the individual circumstances of a case. That's where issues such as the loss of anonymity feed in, and it may not matter. And it may not matter also, given what I've already said, which is we accept that what the cases demonstrate is it's a legitimate approach, effectively, to start by making some general findings about the level of risk in Northern Ireland and then applying them in individual circumstances. So that's why, as I say, it may not make any real risk, any real difference. An example, we say, of which we would say is consistent with our argument that it's at the real and immediate risk stage, but I accept it may not be 100% clear where the issue of individual consideration was applied, is the receipt. That's the relevant passages are at 1226. And you've already been taken to, and I won't take you to it again, it's obviously very familiar now to anyone who's been involved in these two hearings. You were taken to para 43 rather, from the judgment of Lord Justice Girvan. What I would emphasise in that context, and I accept to some extent it's a little unclear quite how the learned judge is applying it, but what is clear from the use of the language possibly significant in the second last sentence I don't know whether you've got that. It talks about an increase, depending on the evidence, essentially, an increase of present threat, possibly significant, depending on the nature of the evidence and other unknown contingencies. So, what Lord Justice Girvan was recognising in our submission was the extent to which risk would increase in a particular case may depend on the particular circumstances of the case. And consistent with that in our submission, at para 46, he then talks about, this is about 15 lines into para 46. It's a sentence that starts, "The state authorities know that evidence, if given openly, could expose the witnesses to an increased risk. That increase could be significant." What in my submission Lord Justice Girvan there is recognising is the increase, it may depend on the particular circumstances, and that's why ultimately in the appeal the way it was disposed of, and you see this from para 47, is that the matter was remitted essentially for the coroner to redetermine matters. And so even though there were some generic findings about risk, findings we would submit that to some extent one has to treat with a degree of caution given passage of time. I'll come back to that. Ultimately, there needed to be consideration of the individual circumstances because, as the subsequent judgments demonstrate, matters such as loss of anonymity may mean effectively there is no increase in risk from an individual giving evidence. That submission we would submit is consistent with the approach adopted by Mrs. Justice Keegan, as she then was, in the Ballymurphy inquest. If you go to 1132 of the bundle, my learned friend highlights para 23, but I would highlight as well para 24, where the learned judge made it clear that she was considering each case on its own facts. And that's consistent with the example she gave. My learned friend took you to page 1169. Sorry, to 1171, but if you look at, for example, 1169, which is another example, what the learned judge was careful to do, and you see this at the end of para 11, para 12, para 13, she makes individual findings about the engagement of Article 2 and then rules essentially on anonymity. One other feature of this that I would highlight, which is perhaps of some significance if you come to make generic findings, is that when looking at when one looks at the findings at 1171, in particular paragraph 3, which is the paragraph my learned friend highlighted, the learned judge talks there 5 lines into that paragraph about the need to bear in mind the nature and profile of the inquest. That's one thing I'd just draw attention to, because on rereading the Springfield inquest, and I'll kind of come to this, the Springfield judgment over the weekend, one thing that is striking in that determination is the weight that Mr. Justice Schofield places on the nature of the allegations that the security forces faced in the Springfield inquest. That was a case where the actions of the security forces were said to have been a massacre. Perhaps something that I've given insufficient attention, or drawn insufficient attention to, and perhaps needs some consideration if you're going to make generic findings in this context, is that, of course, in Omagh, this isn't like a number of the Troubles inquests where the allegations against state agents are that they carried out direct and unlawful killings. This is a situation where the allegations against state agents are of a very different nature. There's no doubt. And I'll come back to that when one sees the Springfield inquest, because it's something that is highlighted by the judge. So turning then to the questions, the first question related to the findings of Mr. Justice Huddleston in the Doherty inquest, and the relevant page in the bundle is page 1786. And the passage that or the passage that was particularly drawn attention to, if my notes are correct, in relation to in the questions, it was essentially paragraph 3, and it was particularly B and C. Can I just start by noting that the context, because it may be of some relevance if one's going to make generic findings. At that time, the risk, as was made clear in paragraph A of subparagraph A, the risk in Northern Ireland from Northern Irish terrorism was described as severe. You'll remember from the previous hearing and from the JTAG threat assessment that the risk in relation to Northern Ireland has reduced. It is now substantial. I make that point not because it obviously doesn't need to be given careful consideration, but because there is a danger in my submission in applying the factual findings that were made by, for example, Mr. Justice Huddleston, because the situation is changing. It continues to change in our submission, and that's a concern I'll come back to when I make some reference to the factual matters highlighted by Mr. Henry this morning.
Can you just remind me what the difference between the two is, Mr. Southey? Substantial.
Sorry, I have got that in my notes somewhere because it's difficult to read. You can see it on the. You can see it in the original. There was like an.
So if I can help, the difference is that severe means that an attack is highly likely. Substantial means that an attack is likely.
Yes, sorry. Can I give you the reference as well, sir? Because that's what I was looking for to find it. You will remember that there was a bundle of original documents for the first hearing. It's page 215. It's not necessarily easy to read on that, but it is. That's where you will find the underlying document that makes that point. And should I'll come back to that. I was going to come back to that for a different point, and I will come back to it. But the ruling, your ruling, sir, we say correctly, recognised that there was a general downward trajectory, and that's important. All we're saying in relation to that is one needs to be cautious in one sense about simply adopting factual findings. Obviously, even more so in relation to Re-C, because that was some time in the past. We then turn to the specific paragraphs that the question asks about, if I may. The first one is B. That is the paragraph which talked about the risk being real. That we accept, obviously, reflects the first element of the Article 2 test. It doesn't deal with whether it's immediate. But probably more importantly, it doesn't deal with the actual impact of giving evidence. But it's obviously an important starting point, and we accept that language reflects the first part of the first limb of the Article 2 test. The second finding that was highlighted in the question is C, and that language in our submission doesn't necessarily reflect the Article 2 test, because it talks about how there could be an increase in risk. How that relates to the Article 2 test may depend on this dispute, which I accept, as I've already indicated, may be slightly academic, this dispute as to where, in the context of the Article 2 test, the need for an increase in risk fits in. But wherever that is in our submission, there needs to, in our submission, be established that there is an increase in risk. What this language recognises in our submission, consistent with what obviously happened in the circumstances, is that one couldn't say necessarily that in every case there will be an increase in risk. That's why, obviously, on the facts of the case, what the learned judge did was acknowledge, because of the widespread knowledge of the witness's name, that there was no increase in risk. You see that at para 6. So what we submit, which is consistent with what I've already said about generic findings, is that what the approach of Mr. Justice Huddleston demonstrates is that it is acceptable, indeed probably pragmatic and a sensible use of time to make generic findings essentially about risk. But that doesn't mean that one doesn't go on to consider the individual circumstances. That's consistent, we would submit, with the Spring Hill inquest, which is obviously one that PS and I place significant weight on. Now, Pearson-I, in their turning to the Spring Hill inquest, the relevant passages start at page 1799. Pearson-I started by drawing attention to what is said in para 31 about reference to standard form. What appears to have happened in Spring Hill was that there were individualised risk assessments, but they were all generic, effectively. What in our submission that demonstrates, and what we submit is important in one sense, is that if there is going to be sort of a generic set of findings that will act as a starting point, it's important then that state authorities who are making applications on behalf of witnesses give some consideration as to, and make it clear that they've given some consideration as to whether there are reasons for departing from that. For example, it may only be state authorities who have an idea of the profile of an individual. It may only be state authorities who know whether the individual now lives in Australia in somewhere that is unknown. The second feature, though, that's important to note also about what was before the coroner in the Spring Hill case, before Mr. Justice Schofield, was that is set out at para 37, and in that case there was specific risk assessments of which use the sort of categorisation that's already been referred to this morning of the risk of giving evidence. And come on to what the JTAG assessment says in this case, but we do submit that's important given, as I say, the importance of not just the risk to police officers, but the risk to police officers and former police officers from giving evidence. Now, that's the first point about the context I'd draw attention to. The second point, just to link back to something I already made reference to, is para 34. And para 34 is where Mr. Justice Schofield made clear that one of the factors that was relevant was the perception, essentially, that there had been a massacre and that soldiers, and what was an issue primarily was anonymity of soldiers, that soldiers were responsible for that, and that might increase their and I'm not saying in any way that's necessarily determinative, but I do submit it is a relevant factor in this case and needs potentially to be taken account of.
Well, I don't doubt it's a relevant factor, Mr. Southey, in the sense that the individual circumstances lying behind any inquest or inquiry will be relevant.
Yes.
What I'm not seeing so easily is how one would begin to rank these individual circumstances, or to put it rather differently, how one would compare one tragedy with another.
Well, the point, as I understand it, that's being made by, and I'm paraphrasing, but hopefully not unfairly, by Mr. Justice Schofield, is because the individual military witnesses, at least in some cases, would have been seen as being responsible for committing, or were seen by some as being potentially responsible for committing serious human rights abuses, that made them higher risk as a target. And that's part of the context in which he was then having to assess the risk to those individuals. We're talking about a situation here where there's no obvious basis for that sort of targeting of people involved, and that to some extent reduces risk. And what I would also point out is that the Spring Hill inquest was certainly not the only inquest of that nature. A number of the ones we're looking at are ones where there were those sorts of allegations, and they clearly fed into the assessments. Turning then to perhaps what is most significantly, or is the most significant point that's in one sense made by PSNI in relation to this inquest, and question one, I suppose, that's certainly where it fits in PSNI submissions. PSNI highlight para 39 and the language of decisively lost. And their written submissions certainly argue that is a high threshold. We submit there is a danger in sort of applying language such as decisively lost, which is that it loses sight of really what the fundamental consideration should be. And that fundamental consideration should be, does what has happened in the past mean that anonymity will have little or no effect? If you think about the Doherty case, all that was sufficient, what was sufficient essentially to mean that there was a conclusion that there should be no anonymity order, was the fact that the name had been mentioned on a significant number of occasions in the past during the inquest. That, in our submission, should be the focus. The focus should be not on some, in one sense, sort of linguistic barrier, effectively, to the lifting of anonymity, or departure from a sort of starting point of anonymity. The focus should be effectively on, will anonymity make any difference? And either anonymity has effectively been lost, so it will make no difference, or it hasn't been. So turning back to the question, what we submit the findings of Mr. Justice Huddleston demonstrate is not that necessarily Article 2 was engaged, because ultimately there needed to be consideration of whether there'd been an increase in risk. What they demonstrate in our submission is how it's open to judicial decision makers and to you, sir, to make generic findings that provide a starting point, but that starting point doesn't undermine the need for individual assessment.
I understand that,
yeah,
Mr. Southey, and I don't disagree with it. I suppose the only question is the extent to which one would engage in that individual assessment and what factors one would take into account and give weight to. And what I can see in the various inquest decisions that have been drawn to my attention are a number of examples in which anonymity has been granted.
yes,
And in probably all of those, there is something said about the individual circumstances of the applicant. Now, in PW9, we know that anonymity was refused, and it's for the very reasons you've just been talking about. But if we look at some of the others, we see circumstances in which anonymity was granted with very little by way of telling individual circumstances that would appear to point in that direction. So what I was wondering about is, and what might be helpful, would be if you were able to identify for me any example of an application which has been refused and draw my attention to the personal circumstances which led to that, beyond PW9.
Well, obviously there would appear to have been another witness who, as my learned friend indicated in the Doherty case, who lost anonymity, or wasn't granted anonymity in part because anonymity had already been lost. I can't think of, I've not been able to locate in the Northern Ireland context a case where in circumstances other than where it effectively anonymity had already been lost. I'm not aware of any. It's always the most difficult thing as a lawyer is to say what you to say nothing exists because you don't know what you don't know. But I'm all I'm in one sense saying, and it goes back to a submission I made last time, and to some extent already touched upon before, is that when making, and I've made clear, I don't dispute the idea that you can do what effectively happened, for example, in the Doherty case, where there are starting point generic findings. All I would also urge on the inquiry is that when making those generic findings, one needs to consider the current situation. One needs to consider the nature of the issues that are raised by Omagh. And one needs to also consider the JTAG risk threat assessment, and that it was what I was going to come on to effectively.
So we've reached a point, I think, where we would recognise that anonymity could be lost in the sort of fashion that was described in PW9, where to grant anonymity would in effect be to bring the proceedings into disrepute.
Well, that's obviously how the learned judge analysed it. What I would submit is that the key point about that, in one sense, is how does that, when one analyses how does that fit into the Article 2 consideration, the primary reason it fits into it is either because, if I'm right where it fits in, because of what already was known about the individual PW9, there would be no increase in risk, or because it wasn't a reasonable step, adopting Mr. Henry's analysis, because it wouldn't make any difference, effectively. And the wider point, that's why I'm keen to, in one sense, avoid narrowing this down simply to cases where anonymity has been lost. The wider point in my submission is that what that demonstrates is that ultimately there needs to be a consideration, at the very least, of whether anonymity will have any impact. And although the most obvious circumstance in which it might be concluded anonymity will have no impact is where anonymity has been lost, it is possible to conceive of other circumstances. That's why I keep referring to the person who's in Australia, basically. Anonymity in those circumstances we would submit, potentially make no difference, because the person's location effectively had addressed their risk.
I'm sorry to interrupt, but could we have a break at this stage? I'm told when it is.
Yes.
It's a technical issue, not a...
I'm sorry to interrupt you, Mr. Sutton.
No, that's fine.
Could we have 10 minutes?
Yes, of course. Greenie.
So the technical issue has been resolved. Our options now are to sit on for just a short period of time and then take the ordinary lunch, or to sit on for what ought to be no more than 45 minutes to complete the submissions. Our preference is the second of those courses, and the stenographer has been good enough to indicate that she's comfortable with that approach.
All right. Are you happy with that, Mrs. Southey?
Thank you very much.
So just to, before I go on to what I was about to do, which was the JTAG threat assessment and the questions in relation to that, can I just indicate, because we've, well, Mr. Henry partly and also my instructing solicitor have drawn my attention to two rulings that may assist in relation to other examples of in relation to anonymity. The first that Mr. Henry located is 2024 NI Coroner 2. That is the ruling of Mr. Justice Huddleston regarding PW 35. As I think we all understood, it is primarily a case of anonymity having been lost. The one complication that I think probably you ought to be aware of is that although effectively anonymity had been lost, the witness then argued that they should be granted anonymity because of the impact on their health, and that argument was rejected. So there was a sort of loss of anonymity, but then a follow-up from the witness. The other that my instructing solicitor drew attention to is 2025 NI Coroner 5, which is a ruling of His Honour Judge Gilpin in the inquest into the death of Patrick Crawford. That is a case where anonymity was reviewed, having initially been granted towards the end of the inquest, because the witnesses had died, and in fact anonymity was maintained because nobody sought the lifting of anonymity, but it possibly is an indication of the sort of circumstance, again, where anonymity in principle may be an issue, because if someone is dead, depending on what, for example, their family situation is, it might be said that anonymity would make no difference because unfortunately they are no longer a potential target. And certainly the coroner seemed to have regarded it as a potential change of circumstances, but then didn't actually lift anonymity because nobody was seeking that. But neither of those, I suppose, are direct answers to your question, but they're worth clarifying, I think, given the question asked.
Well, that's helpful. Thank you, Mr. Southey.
Can I then turn to JTAC, this JTAC assessment? A couple of things just that I'd like to say to put it in context, and put in context my sort of response to the questions that were asked. Two things first that should be noted about it. Firstly, if one looks at the first page of it, page 144, that is where there is the reference to the downward trajectory in relation to threat, and that is where the reference is found also to the peak threat being 2010. And I just draw attention to that because my learned friend, Mr. Henry, drew attention to the tragic killings of Constable Carroll and Constable Kerr. They, of course, occurred during that peak and to some extent in our submission, as a result, are of perhaps less significance than they might be, because fortunately things have improved since then, and that's also demonstrated by, as already indicated, the threat level now is substantial, which is a reduction. More importantly, though, the question two, if my notes are correct, focuses to some extent on the last paragraph, and in particular the last sentence of the last paragraph, which is the question of whether or not there is which was the statement, rather, that there is a realistic possibility that the NIRT threat will increase. That sentence should be read, though, with what follows, which is the reference to any increase in the level of threat being dependent on the receipt and nature of subsequent intelligence. And that's an important starting point in our submission, because it does in our submission demonstrate that two things. One, a recognition that there isn't necessarily going to be an increase in any particular case, and whether or not there's an increase may depend on future intelligence. And secondly, it reflects, it in one sense highlights the fact that the language of realistic possibility in our submission doesn't necessarily reflect the Article 2 test. It is, we would submit, potentially there's a potential material difference in the sense that real risk essentially is a test which is both recognising the fact that there is inevitably uncertainty about whether there will be an attack or a threat to life, but at the same time, real risk does suggest that there needs to be a degree of risk that is beyond that, effectively, that is inherent in everyday life, where we all run risks all the time, but in one sense just have to accept that that's part of human life. And we submit that one needs to be cautious about applying language such as that's found in the last paragraph, real possibility, particularly in light of what follows, the second sentence. That, in our submission, links into question 3, and the question 3 in part focuses on how one should read JTAC. And in our submission, with one important qualification, and that is the qualification that where JTAC uses language as it does at the top of page 145 of substantial, it is clear it is using a formal gradation system to identify a level of risk. In our submission, it should be read in a common sense way, recognising that it isn't written, for example, as far as we're aware, by lawyers who understand the Article 2 test. It is written by security professionals who are expressing themselves in a common sense way. And that's important because obviously the role in our submission of the inquiry is to convert what is said essentially into or to apply what is said in the context of the Article 2 test. And that test, what I've just said, links into a submission that my learned friend, Mr. Henry, made this morning about the protective or the precautionary approach. And my learned friend said that in relation to that, one of the reasons why the precautionary approach applies, and I'm going to come on to question 4 in a moment, but one of the reasons why it applies is that there is inherent uncertainty. And we accept that there is a degree of uncertainty, but we submit that uncertainty is reflected in case law like Begum that deals with how a risk is assessed. And that's, that case law makes it clear that risk, it's not the sort of fact-finding that perhaps judges spend most of their time doing, where they are considering either the civil standard of proof or the criminal standard of proof. Risk assessment involves taking account of a number of different factors and reaching a conclusion, not applying balance of probabilities, but still reaching a solid conclusion about risk. And in our submission, the real and immediate risk test it shouldn't be in any sense watered down by reference to precautionary approach or whatever. Ultimately, the question for the inquiry, based on the JTAG approach, in our submission has to be, is there a real and immediate risk associated in particular with giving evidence to the inquiry? I've just touched on precautionary approach and question 4. Can I then deal in detail with question 4? Our submission in relation to the precautionary approach is that the precautionary approach applies to the second element of the test, not the first element of the test. And the reason we submit that in our submission is twofold. One, what I've already touched upon, which is that the Article 2 engagement test, if I can put it that way, or the first element of the test, is clear, well established, and doesn't need qualification. It is flexible enough to take account of the uncertainty. That's why it talks about risk, not, for example, requiring something proven to balance the probabilities. And it's the second stage at which the precautionary approach comes into effect. And that, we submit, is consistent with Jordan. If one goes to the authorities at page 1288, Mr. Justice Stevens, as he then was, he summarises what is meant by the precautionary approach at page 118, and in particular says that it describes how it effectively comes into play in carrying out a balancing exercise. And we submit that balancing exercise, if one thinks back to what I've already said about Osmond, the only stage at which there's a balancing exercise is at the second stage. It's at the second stage that the state has to take proportionate steps. Can't necessarily take every step, but it has to assess what is a proportionate step. And in that context, it's relatively easy to see how a precautionary approach fits in. At that stage, when looking at whether a step is reasonable, it becomes, in our submission, easy to see why it may be necessary to take account of uncertainty, essentially, about what will work and what won't work. Now, the note from the inquiry highlighted one of the Doherty reasons, judgments rather, and it's the May 2023 one, which is at the relevant passage is at page 1824 of the authorities. And it's it was particularly paras 7 to 9, I think, that were, sorry, if I remember rightly, were highlighted. And in that judgment, that's, I should say, 2023 NI Coroner 5. In that judgment, Mr. Justice Huddleston at paras 7 noted the real and immediate test that the noted that the issue was whether there was an immediate risk that wasn't fanciful. He then, at para 8, said the coroner is also entitled to take a precautionary approach. So he seemed to regard that as something that was supplementary to the real and immediate risk test, not something that was sort of part of the application of it as we read that. He then, I accept, indicates that applying that, it's relevant to take account of even a low increase in risk. We submit, if we're right, that in fact that increase in risk needs to be considered primarily at sections part 7, where you're looking at whether there's a real and immediate risk for the reasons I already gave. But in any event, in one sense, what one sees here is precautionary approach potentially feeding into the consideration, as I say, after the consideration of real and immediate risk. He then applies that at para 15 and appears to, we would submit, apply the precautionary approach after, and one sees that in particular from the way in which he approaches anonymity in paragraph Roman 1 within para 15, he appears to approach that as essentially being something he considered after the engagement of Article 2 when he's considering whether or not anonymity is a reasonable step. So we would submit, at the very least, Doherty is not entirely clear about where within the Article 2 analysis the precautionary approach applies. In those circumstances, one should follow the approach essentially of Mr. Justice Stevens, because it fits in our submission conceptually within the sort of key authorities such as Osman that set out the proper approach to Article 2. And so overall, what we submit in relation to question 4 is that the precautionary approach only feeds into the second element of Article 2 analysis. It's about the state being in a position, effectively, if there is a real and immediate risk, to guard itself as able to take precautionary approaches because such steps are reasonable because of the uncertainty, essentially, about the way in which risk will manifest itself. That, I hope, deals with the questions. Overall, as I say, what my answers probably demonstrate is that I don't, as I understand it, see a huge amount of difference between the parties. There is general agreement that one needs to consider the individual circumstances. My learned friend, helpfully, I think, clarified that the PS&I position is one shouldn't close down the circumstances in which anonymity may be inappropriate. Although loss of anonymity is probably the most obvious example, it would be a mistake to say never say never about other circumstances in which anonymity may need to be lost. None of that means one can't make generic findings as a starting point. We say that there needs to be a little bit of care applied when applying the JTAG ruling, part for the reasons I indicated, which are the language doesn't necessarily mirror Article 2, and not only does it not necessarily mirror Article 2, but it's not written necessarily by lawyers who understand that the technical meaning of the Article 2 test. And any generic findings need to take account of the fact that there have been significant improvements in the security situation in Omagh, and the point I made before, which is this isn't, unlike some inquests, a situation where the security forces are to use, for example, the language of Ballymurphy being accused of being involved in a massacre. That need for individual consideration does mean in our submission that we would emphasise something that we've emphasised all the way through, and I repeated earlier this morning, which is that there is a need for candour, there is a need for public authorities who are seeking anonymity to be open about the extent to which an individual's past is known, and to be open about any other circumstances that may mean that in the particular circumstances of the case, risk is not what it might generally be said to be. I think that covers everything, sir.
Thank you, Mr. Southey.
So I indicated at the beginning that Mr. Mansfield may wish to make a short submission at this stage. He wasn't certain that he would want to do so, so may I check whether he does want to say anything?
Thank you, Mr.
I wonder if I may just add a little bit. We have submitted a written submission, which you've seen, supporting the families, and we've left much of the detail to others to, as it were, submit. However, there is one point I'd just like to take up, something Mr. Southey has said, linked to what Mr. Henry has said today, and it is the question of accountability. One has to pause and remember that these submissions should not be seen in isolation, and I think you're only too aware, perhaps acutely aware, of what's about to come down the track, which is in fact another set of not unrelated submissions concerned with closed material. And there are going to be overlapping factors. And the reason I add this note at this point, going back to what Mr. Southey said today about accountability, is that the family I represent are concerned in the longer run that we may have a situation in which the families and the public are not made aware, for reasons to do with the restriction orders, not only of the identity, that's part of the situation, but more importantly of the substance of actions that may have been taken by certain individuals. And in the context of this inquiry, given the gravity of the original offence and also the repercussions from that, the need for accountability and truth at the same time, that is one of the objectives, we say only obvious, for the purpose of this inquiry. And of course, the section that's been referred to already and will be referred to again when you get closed material, that you have a discretion, and it's where the chairman considers an order to be conducive to the inquiry fulfilling its terms of reference. Now, I just want to expand on that particular phrase because it's obviously interpreted normally as relating to the need for a restriction order in order to fulfill the objectives. But we're saying there is another aspect to this, and that is satisfying the obligations that you have and the discretion you have. So, for example, the position adumbrated by Mr. Southey is a small thing whereby anonymity might be lost. And it might be lost in a context of accountability which is linked to the substance of the narrative, and I'm going to put it shortly. One of the main narratives here is preventability. It is perhaps the core issue. And linked to that, linked to preventability, is undoubtedly issues concerned with, and we've put it in a later submission, which you'll be reading later, but we're concerned that preventability hinges in large measure upon one particular factor, and that is intelligence and what was known and what wasn't known. There's been a lot of publicity about it in any event, so that issue, that sort of dimension mentioned in the context of anonymity also affects what may come in relation to the closed material. So what the Rush family I represent are concerned about here is that we are hoping that you won't be, as it were, compelled to find yourself in a cul-de-sac whereby the people responsible for whatever inactions or actions have been taken that bear upon preventability and, for example, intelligence, are not made known at any stage, but obviously worse, and I'll deal with it when we come to closed material, that the actual substance of what may or may not have gone wrong is not made public. And so we say that there is this other thread of the obligations under the Act, of, in other words, enabling you to essentially fulfill those and do things that are, and actions that are conducive to the terms of reference, which is how that section is worded. So we would say at this stage, even though I'm preempting the next stage, I would ask that you bear in mind what is just over the horizon, because it has a bearing itself on identity and narrative. That's not to say undermine every single application for that reason, but there will be some in that narrative that require a public accountability, and otherwise one would look back and wonder what has been the purpose of the whole exercise if those matters are not canvassed and addressed in the spirit of transparency which you've mentioned yourself. Thank you for allowing me that time.
Thank you, Mr. Mansfield.
So we're very grateful to Mr. Mansfield for those submissions, and we know that he and everyone listening will bear in mind that you, sir, have on a number of occasions made plain that you will have the importance of the principle of open justice at the forefront of your mind throughout any decision making that you have to engage in. So the inquiry legal team is grateful for the submissions that we have received and that therefore you have received, both in writing and orally, on the issue of anonymity. And we hope and believe that they will give you the assistance that you have sought in relation to that issue. For our own part, we don't propose to say any more about anonymity today, but instead we will simply indicate that we will meet again on the 7th of September for the closed material restriction order hearing, the CMRO hearing to which Mr. Mansfield has just made reference. And so we believe that that concludes the proceedings for today, subject of course to anything further that you wish to deal with.
Thank you very much, Mr. Greene.